A repeat offender admits to theft, hoping an 8-month plea deal will end the case. But then the judge asks one simple question that changes the entire courtroom atmosphere. Moments later, another defendant facing probation revocation gets an unexpected second chance instead of prison. Why did one man walk away with jail time while the other stayed on probation? Watch until the end to see the judge's reasoning and decide for yourself.
Court is calling 2026 CR 006-336 State versus Eloy Roscoe. Can I have parties announced?
Yes, Judge.
Roberto Vargas for the defendant, ready to proceed, Your Honor.
And are you Mr. Orozco?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Orozco, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we waiving this punishment enhancement, but otherwise proceeding as charged.
No objection, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with theft, less than $2,500 with 2 or more previous convictions. As a state jail felony, the range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 8 months in the state jail facility. There are no applications. The state is taking in consideration 2026 CR 008404 and 2026 AL 001983. Did you understand that to be your plea?
Yes, ma'am.
Defense and state, is that the plea?
That is a plea, Judge.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Judge, we offer City Exhibit number 1, including all of its attachments.
No objection, Your Honor.
I state you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right, this Sephora that's on San Pedro, is that the one that's in the mall?
Yes, ma'am.
All right, why are you stealing from Sephora?
I lost my job and I was just trying to catch up with my car bill and my rent.
All right, how many times have you lost your job?
3.
All right, so every time you steal, it's because you've been losing your job?
No, ma'am.
All right, if everybody stole when somebody lost a job, we'd all be thieves. and nothing would get done. You can't do that. There are plenty of places that are free for you to help you with your food, to help you with housing, all of that.
Smooth.
All right, the court is finding you guilty. The court will sentence you to 8 months in the state jail facility, taking consideration 2026 CR 00404, 2026 AL 001983. There's to be no contact with Sephora and no contact with North Star Mall. Did you review, and no unsupervised contact with children? Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because it's plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Make better decisions. Okay?
Question, ma'am.
Yes.
The no contact with children, what does that have anything to do with that?
All right, let me ask you something.
Oh, just-
Okay, let me explain it to you. You are deemed a habitual, right? So that means that you've been to prison more than once.
Yes, ma'am.
Would you want somebody who's been to prison more than once having contact with your children unsupervised?
No, ma'am.
There we go.
Thank you.
All right, thank you.
Thank you. Your Honor, may I have excuse?
Make sure that I have the dismissal.
Oh, yeah.
Right now, Judge.
Thank you. See you next time.
Thank
Thank you.
you. Thank you.
Thank you.
Oh, and you're right. Thank you. Thank you. Thank you.
Appreciate
Yeah, have a good day. Thank you.
Thank you. The parties on Christopher Charles Gibbons. Gibbon? Okay. Hold on. All right. Court is calling 2026 CR 000637 and 2026 CR 000659. State versus Christopher Gibbons. Can I have parties announced?
Well, that's even for the state of Texas.
And Richard Garcia for the defense. Ready, Your Honor?
All right, and are you Christopher Charles Gibbons? Did you review the motions to revoke community supervision with your attorney? Did you understand it? And the cause number ending in 37, are you the same Christopher Charles Gibbons who was placed on probation for unlawful possession of a firearm by a felon for 5 years? And in cause number ending in 59, placed on community supervision for possession of a controlled substance, penalty group 1, 4 to 200 grams for 5 years. Is that you? All right, state, are you proceeding on the same violations in each motion?
Your Honor, the state is proceeding on violation of condition number 1, both motions.
All right, state, you may proceed.
Yes, Your Honor. On or about the 30th day of June 2026 in Bexar County, Texas, the defendant, Christopher Charles Gibbons, committed the offense of unlawful restraint, violation of condition number 1.
To that, how do you plead? True or not true?
True. Now the state remains waive the remaining violation.
Any objections to the waivers?
No objections, Your Honor.
All right, and the cause number ending in 37, did you understand by pleading true to violation of condition number 1, the court could find it true, sentence you up to 5 years into prison and up to $1,000 fine? And in cause number ending in 59, by pleading true to violation of condition 1, the court could sentence you to 5 years in the prison and up to $1,000 fine. Did you understand? Knowing that, do you wish to continue to plead true to violation of conditions 1 and 1 in each motion? In each motion, the court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Your Honor. The state would ask that this court take into consideration the pre-file case, the unlawful restraint,
Okay.
that the defendant pled true to. We would also ask that this court continue the defendant on his probations, make him complete a batterers intervention program class, as well as weekly reporting for a period appropriate to this court, perhaps 90 days.
Okay, so why would I do this?
Yes, Your Honor. So the reason for the PIC and the reason we came to this agreement instead of a contested, we have never had contact with our victim in this case. The initial unlawful restraint was this defendant and his. Yes, Your Honor. I do need to type. Yes, Your Honor. This defendant and his girlfriend were at their apartment complex arguing. The defendant maintains that a maintenance individual had a firearm in the parking lot. He then removed his girlfriend back into the apartment and would not let her leave at that time due to that maintenance man in the parking lot. I will tell this court that when police responded and spoke to the maintenance man, they never identified the firearm, so no charges were ever brought against him, but that was the unlawful restraint case. And once again, Your Honor, the state has never been able to establish contact with the defendant's girlfriend.
And what is the girlfriend's name?
Your Honor, her name is Sharelle Cole. Sharelle Cole.
How do you spell the first name?
SHARELL.
Wait, SHARELLE.
Yes, sir.
And the last name?
Cole, COL.
You get that too. See? All right, probation, is this probation's recommendation?
Yes.
All right, and cause number 2026 CR 0000367. I'm sorry, 637. The court is finding violation of condition number 1 true. Court will deny the motion, alter and amend conditions to the following. The BIP course, and there's to be no contact with Sharelle Cole. Taking consideration 2026 PF 27018. And I'm going to ask for the MRT course. Probation, do you want anything else?
Judge, Mr. Dickens failed to report. No, that was the condition that was waived for the month of May.
Yes.
Was like weekly reporting for 30 days.
Weekly reporting for 30 days. And then we're going to go into cause number 2026 CR 0000659. The court is finding violation of condition number 1 true. Deny the motion, alter and amend conditions to include the BIP, no contact with Sharelle Cole, taking consideration 2026 PF 27018, the MRT, and weekly reporting for 30 days. Is there anything else?
Nothing to say, Your Honor.
Nothing from the defense. Thank you, Your Honor.
All right, thank you.
What do you think? Did the judge make the right decisions in both cases? Or would you have ruled differently? Share your opinion in the comments. We read every response. If you enjoy real courtroom proceedings, judge rulings, and legal case breakdowns, make sure to subscribe and turn on the notification bell so you never miss our next courtroom upload. Thanks for watching, and we'll see you in the next case.